let's see the next topic that we have. So Unit 5, 2 legislations are there as we mentioned. Second one that we have is Probation of Offenders Act. Okay, so we will see what this legislation is all about. This legislation that we have is Probation of Offenders Act. So now what is probation? Probation is nothing but release of offender from detention. Otherwise, it happens that once a person commits a crime, whether it's IPC or some other legislation, punishment is also being mentioned there. That maximum 3 years, maximum 5 years, whatever is the punishment, based on that the person should ideally be punished. But sometimes it might happen that because already the prisons are overcrowded, right? And sometimes it may happen that a person, because of the situation or something, he just ends up committing a crime. Might be he is otherwise a good person. He is otherwise not belonging to any like criminal background. He is not having, might be he is otherwise having like a very good record. Okay, because of situation or something, he just ended up committing a crime. In such cases, rather than sending that person in prison, because anyways, in Indian legal system, main aim is to reform the person, right? Like we say, hate the sin, not the sinner, because the person commits a crime based on the situation. He is not born a criminal. So we say that there is always a possibility that we can reform a person. So why to send a person to the prison if he is someone who is otherwise a good person, doing everything good, no criminal record, no previous offenses, nothing? In such a case, why can't we, release the person? So that provision is given under this legislation, Probation of Offences Act. Even if some offense is being committed, probation can be granted. And what is probation? It is nothing but release of offender from detention. Otherwise, the law says that yes, this person should be detained for 5 years, 10 years, 2 years, 2 months, whatever. Can we release the person or not? If we can, what all other situations or conditions under which we can release such a person? That provision is given under this legislation. Okay, legislation of 1958.
Yes.
And if you remember, we had discussed one topic before also, which is this one, security for keeping peace and good behavior.
Yes, I remember, madam.
You remember, right? Like just like bond agreement, they would sign a bond wherein they would say that, okay, I would maintain good behavior, I will do this, I will maintain peace and everything. And this is also something which comes into picture over here for this legislation. Okay, now as we say, hate the crime, not the criminal, because we believe that a person is not born as a criminal. Because of the situation, he ends up committing a crime. And that is why we want to eliminate the crime. We don't want to eliminate the criminal. That's why death penalty is given only in rarest of rare cases, because we feel that there is always a possibility that the criminal can reform himself. Right? So criminal law in India is mostly focusing on reforming the offenders rather than punishing them. Punishment, the main purpose is again to reform the person. If there is already a possibility that we can reform him without even punishing, why not take that option rather than overcrowding the prisons and everything, right? It is true that punishment gives a sense of satisfaction to the society. Definitely, when the criminal is punished, society would feel that, okay, fine, this criminal got punished, law prevails. But even after that, and also the victim would feel satisfied that, okay, he had committed some crime, he has got the punishment. But even though it leads to a sense of satisfaction, we also need to consider that prisons are overcrowded and it incurs a cost on the government also to maintain them, right? So in such a case, if it is possible, why can't we probate the offender? So instead of keeping the accused with other criminals who are like maybe habitual offenders or maybe some serious criminals, because this person would mingle with all those people, there is a possibility that his mindset might also change. Rather than reformation, he may, on the other hand, become like them only. His mindset might change. And also when a person remains in prison for months and years altogether, it becomes very difficult for him to again go back to the society and adjust, right? So in such a situation, why can't we probate the offender? That is what this entire legislation is all about. So this is based on this reformative approach that we anyways have as a theory of punishment. Also, we want to reform the criminal. When we look at the legislation, it's a very small legislation. Okay, it's a very small legislation. Let me open the barrack also. Yeah, so this is the legislation having only 19 sections. Okay, and the first initial sections are the ones which are very much important. So what is this entire legislation all about? Definitely first one is like the title of the legislation and all of that. Secondly, it talks about application. So what do you think about the application of this legislation? Where is it applicable?
Is applicable all over the country?
It is applicable to the whole of India. Even in Jammu and Kashmir also it is applicable, as well as Ladakh. Okay, so this legislation is applicable in whole of India. Then it provides for some definitions like code. Whenever they are mentioning code, it means the criminal procedure code, because we are talking about punishments under criminal procedure code. Probation officer means an officer appointed to be a probation officer or recognized as such. So some persons are appointed as probation officers who would do the needful, and they are considered as probation officers. So it is also given under section 13 of the legislation. This is what probation officer is. A person who is appointed as a probation officer by state government or recognized as a probation officer by state government. A person provided for this purpose by a society recognized in this behalf by the state government. In an exceptional case, any other person who in the opinion of the court is fit to act as a probation officer because of some special situations, they also may be considered. Then words and express, whatever is used, this is like in reference to code of criminal procedure, right? What is not defined in this act, we can take help of criminal procedure code, because this is like it adds on to the provisions of CRPC, right? So these are few definitions which are being given here, and after that the proper provisions start.